My lord, I'll take you through the brief facts first. The facts of this petition are non-disputed. My lord, the petitioner and the first respondent participated in the recently concluded general election, by-election, Kawempe North constituency, as candidates. My lord, the second respondent returned the first respondent as the winner and was gazetted on the 24th day of March 2025. My lord, the petitioner was aggrieved by this declaration and hence brought this petition, chiefly on two grounds. Ground number one, that the election was conducted in non-compliance with the provisions of the law, and that non-compliance, my lord, affected the results in a substantial manner. Secondly, that the first respondent and his agents, with his knowledge and approval, committed illegal practices on the election day and before the election day. My lord, during trial, 4 issues were agreed upon to be disposed of by this honorable court. The first issue, my lord, was toned a little bit down on the last day of cross-examination when the first respondent applied to expand a few affidavits. So, my lord, then the issue reads whether the affidavit of Ben Mukasantale, there were 3, but 2 of them were expunged. Whether the affidavit of Ben Mukasantale in support of the first respondent's answer to the petition is legally admissible. Issue number 2 for the court's determination is whether there was non-compliance by the second respondent with the provisions of the Parliamentary Elections Act relating to elections, and if so, whether the non-compliance affected the results in the substantial manner. Issue number 3, whether there was an illegal practice or any other offences under the Parliamentary Elections Act committed by the first respondent in connection with the election, personally or with knowledge and consent or approval. Then lastly, my lord, what are the remedies available to the parties? My lord, during the course of the hearing, we indicated to you, my lord, that we shall raise preliminary points of law. The court guided your lordship that we shall raise them at this stage. Final submission.
Sorry to intervene. I have an issue with the way he read out issue number 2. I don't think we agree that the way he amended it is not how the court captured it. The issue was whether there was non-compliance with the Parliamentary Elections Act, not with the second respondent. And if so, where it affected the results in a substantial manner. So I think it was not specified that we had framed the issue of non-compliance with regard to the second respondent. It was a provision of the Parliamentary Elections Act. So if he addresses it the way, or if it captured it that way, it will affect the way we have prepared the submission.
Okay, that one can immediately clear. So what I have on record is whether there was non-compliance with the provisions of the Parliamentary Elections Act, and if so, whether the non-compliance affected the results of the election in a substantial manner.
That's my lord.
So that's the issue.
I am obliged, my lord. My lord, we indicated I was saying that we indicated that we shall raise preliminary points of law, and the court guided that we shall raise them at this point of the final submissions. My lord, the first preliminary point of law is that affidavits is in respect of affidavits that predate the answer to the petition. It is in respect of affidavits that predate the answer to the petition. My lord, the record of the court reflects that the answer to the petition was prepared, sworn on the 23rd day of April 2025. It also reflects that the affidavits of David Lewis Rubongoya, the record also reflects that the affidavit of David Lewis Rubongoya, Ben Mukasantale, Sylvia Nachobe, Damba Kezekia, and Chibilige Musa was sworn on the 22nd day of April 2025. Now, my lord, the problem with these affidavits is that they support an answer that had not been existent. They are sworn a day before the answer is in existent. And my lord, Rule 81 of the parliamentary elections rules permitted the first respondent to file his answer once he was served with the petition. Rule 81.8.8. Rule 8, sub-rule 1, permitted the first respondent to file.
Please come again, Mr.
8.8, sub-rule 1.
8.1.
Yes, 8.1.
That's all, 8.1.
Yes, 8.1, my lord. Permitted the first respondent to file his answer, and that answer would constitute a pleading.
Please proceed.
And his answer would constitute a pleading. My lord, in Kayanja vs. DePaul, this authority is on page 22, volume 1 of our authorities. Is on page 22. It was held, my lord, that the answer. Yes, it is the highlight. It starts at page 1, my lord. Yes. It says, my lord, that the answer to the petition is like a pleading akin of a written statement of defense. The answer to the petition is a pleading akin of a written statement of defense. My lord, in an ordinary suit, what this case is trying to tell us, in an ordinary suit, an answer to the petition is the suit, is the written statement of defense. You cannot bring evidence before you file the defense. Before you prepare the defense, you cannot prepare evidence. In fact, my lord, without that pleading, any preceding evidence would be anticipatory, would be speculatory, and court cannot act upon it. I'm fortified by the decision of Phyllis, Wamaitha, Wahinia, and others. My lord, this decision is on page 29. Page 29 is where the decision starts from. There you go, my lord.
What does that
It's my lord, the law contemplates commencement of a suit before an affidavit can be sworn. My lord, you cannot swear an affidavit. You cannot swear an affidavit before a suit is filed. The first respondent could not swear. These affidavits could not be sworn before the first respondent filed his answer to the petition. And my lord, the authority uses the word swore. It's not anything else. It follows, therefore, your lordship, that swearing and preparing of any evidence follows existence of a pleading, which is in this case an answer to the petition.
Just continue. I will just have a few things.
I am obliged. In Welltown My Lord Holdings, Welltown Holdings Property Limited versus Rudolph Traders.
That's another decision.
Yes, this is another decision. It's at page 32. Yes, page 32.
Same volume?
Yes, same volume, my lord.
32.
Yes, it's at 32, but the highlighted part is at 76. Yes, my lord. My lord, this is where the decision starts from. Yes, my lord, that is the case.
The name page is location. What's the name of the what are the names of the parties?
Welltown Holdings Property Limited. Welltown Holdings Property Limited.
What's the name of the case?
The my lord is on page 76. The Supreme Court of Australia. The Supreme Court of Australia held, my lord, that in the present context, there is no reason in principle to distinguish between an affidavit that predates the demand by 2 days, and an affidavit that predates the demand by 13 hours, where the 13 hours difference results in a document being signed on a different calendar day. My lord, what happened in this case is that someone made an application for a demand, but filed an affidavit verifying the application for the demand first. Now, the Supreme Court said that cannot happen. You cannot, that affidavit cannot verify a demand that it predates. My lord, it is like giving birth to the child before getting pregnant. You cannot, our point, my lord, on this issue is you cannot swear, you cannot prepare, you cannot file evidence before the pleading is prepared like it was done in this case. Moreover, my lord, these affidavits tell a blatant lie about themselves. They were sworn on the 22nd before a commissioner for oaths, and they are saying they are supporting an answer that was not in existence by that time. And my lord, the law does not treat that blatant lie lightly. In Mianjamba Bali, my lord, versus Birekera Onsuruga, election petition number 36 of 2011. My lord, the holding is at page 150. Mianjamba Bali, the holding is at 150.
No, the case itself. That's the case itself before it goes to...
Yeah, the case is on page number 96.
Page 96?
Yes, page 96. Yes, my lord.
Okay.
It was held in that case, my lord, a sworn affidavit is not a document to be taken lightly. An affidavit which contains falsehoods is suspect on that account. And my lord, the court went ahead to strike it out. We invite you to strike this affidavit out. The holding is at page 150. We invite you, my lord, to strike out those affidavits. First, for predating the answer they seek to support, and second, my lord, for telling a blatant lie in view of Mianjamba Bali versus Suruga Birekera. My lord, the second primary objection relates to the affidavit, to the annexure on the affidavit of the first respondent. My lord, during his cross-examination, the first respondent identified this annexure called the parking list, identified it as a parking list, but my lord, throughout his evidence, he does not make mention of this annexure. When you go to the annexure itself, it speaks about itself as annexure A. It speaks about itself as annexure A, but in the whole of his evidence, there is no annexure A. My lord, this makes the annexure alien, standalone, it makes it alien and standalone to the affidavit of the first respondent. My lord, even if someone was to say that the annexure is identified as TD because he has a mention of, he attaches it as TD in his evidence, but when he brings it, it is marked A. Even if we are to, this court was to take that annexure is TD, my lord, it offends rules 8 and 9 of the Commissioner for Oaths rules. For the fact that it was not sealed and commissioned by the Commissioner for Oaths. My point, my lord, is that Annexure 3 attached to the affidavit of the respondent is not sealed, is not commissioned, and it offends rules 8 and 9 of the Commissioner for Oaths rules. Well, sealing and commissioning of documents is not a matter of choice. Sealing and commissioning of documents is not a matter of choice. It is a command of the law under those provisions that I have just cited. My lord, in Egypt Air Corporation, this authority is on page 158. 158. The holding is on 160. In Egypt Air Corporation versus Safish International Food Processing Limited and Pan World Insurance Company Limited. The Supreme Court, my lord, had this to say. We would like to point out that sealing and marking annexures to an affidavit is a legal requirement. Supreme Court. It is a legal requirement which inter alia facilitates the easy identification of annexures, and in our view, the procedure must be adhered to. The procedure must be adhered to. First, my lord, the annexure in evidence is not identified. But even if we say that it is identified as TD, it is not sealed and commissioned. And the Supreme Court is telling you, you must adhere to those provisions which command commissioning and sealing of annexures. My lord, that position was restated. That position was restated. If you go on page 165.
The same point.
Yes.
Same point.
Yes, my lord.
I think one case will suffice for this point. You don't have to fight so many.
Well, I'm obliged.
You have one decision of the Supreme Court. You don't have to agree to talk about the same issue.
I am obliged, my lord.
Just one case. Especially if it's the Supreme Court.
My lord, if non-identification of the parking list by the first respondent has not satisfied you, and non-commissioning has not satisfied you, my lord, this annexure has a second defect. It is a document belonging to the second respondent. It is a document belonging to the second respondent given to the first respondent. And my lord, that makes it a public document under Section 73 of the Evidence Act. the report, my lord, reflects that that document is not certified. That document is not certified, and therefore cannot be admitted in evidence in accordance with sections 75 and 76 of the Evidence Act. My lord, in cross-examination, when the first respondent was asked why the document is not certified, he said it is a technicality that his lawyers would answer. My lord, there is no technicality in certifying public documents. The petitioner had 29 documents to certify, and she certified all of them. The respondent had just one, the backing list, and he refused to certify it. My lord, that put it far away from admission in accordance with sections 75 and 76 of the Evidence Act. My lord, in Betty Centum versus Naira Libya,